Yeah, so another thing I wanted to mention when it comes to courts, this is more particular in your state, but depending on what state you live in will matter. So, like, for example, okay. Before saying anything, courts have a doctrine called the constitutional avoidance doctrine, which is basically that they'll try everything they can to not rule on a constitutional issue that they can rule on it on a statutory aspect of the law. Basically, if they can't reach that conclusion, then they'll argue, then they'll rule on a constitutional aspect of it. Basically, so for example, there's a couple of states like Pennsylvania, New York, Washington, California. I'm sure there's other states, but the ones that I know of so far, and it happening to me in Pennsylvania, basically, when it comes to 18 USC 922 G4, there are different types of. I'm sorry. That's a commitment, basically. If you're put in a mental institution and you're committed, and you're not allowed to have a gun, but before that even happens, there's different types of commitments. You can have a voluntary commitment. You can have a emergency hold, and then there's a involuntary commitment. All different states define their commitments differently, but for the purposes of 18 USC 922 G4, to be barred, you have to be committed by a court, board, or other lawful authority according to the statute and federal law. Sometimes, and this is really stupid, those four states that I mentioned, what they'll do is you could be held for an emergency hold, which is not a commitment under federal law, just under their state law, and they basically they'll report your hold to the federal government, but the federal government, they don't do any investigations when it comes to any type of any type of uh, information they get from the state government, basically. So once they get the information, then they just bar you for life, basically, without looking into it, basically. And technically, what the state governments are doing is unconstitutional because, based off of the Wilburn versus Barr cases and the Franklin versus Sessions cases, those are both federal cases in federal court where I live in Pennsylvania. Though those aren't binding, those are persuasive. Um, and then there's a memo that I think ATF or something, they sent out a memo which basically explained what qualifies as somebody being like what qualifies being prohibited if you're committed as opposed to observationally observed by a hospital. Those are two different things. If you're observed, you're not barred from having a gun, but if you are committed by a court, board, or other lawful authority, then you are barred. Basically, because of those all that case law and those memos and stuff, certain courts have ruled that that an emergency hold that your state does not qualify as a commitment. Therefore, you're not barred under federal law. But what the states will do, and it's unconstitutional, is that they'll still report your holding to the federal government. And again, that's exactly what happened to me because under PA law, we have something called a 201, which is a voluntary admission. Then there's a 302, which is a technically an emergency hold in the textual aspect of the state law and how they define it. It's observational. There's no mention of any commitment whatsoever. But because of how Pennsylvania is, they bar you for life in PA, but then they'll send that information to the NICS database system, and that's what happened to me, which fucked me. But that is technically unconstitutional based off of precedent from previous courts and the memo from the federal government. And that's what it should. It should not be that way, because in order to be committed, you need your day in court. That's what a 303 is here in Pennsylvania, is when you have your day in court and you're committed by a judge. Now, other states have different ways of doing it, but you have to be weary that if you're ever in the hospital for 72 hours, at least in California, Washington, New York, Pennsylvania, they'll still report your holding to the federal government, even though technically they're not supposed to. And that's also where people get fucked. And I'm sure there's other states that do that too. But be wary that you can still be barred under federal law by the mere fact that your state violated your rights because you never had a day in court to be heard, basically. And like I said before in the previous video, regardless, you would have to. In those 4 states, you can. Those 4 states are still within those 33 states that can apply for state and federal relief through state court. So under that thing, it wouldn't really like my whole video before about you going to the police academy or working for the government isn't going to really work. It's not going to necessarily work for an injunction because you can file it in state court. And like I said, because of the constitutional avoidance doctrine, they won't take that case if you can fix it statutorily, basically. And that's where, like I said, the Wilburn cases and the Franklin cases come into play in Pennsylvania because those cases, they allege that that though the 302 and PA was a emergency hold, that doesn't constitute a federal bar under 18 USC 922 because they weren't committed involuntarily. But what they did is they argued the statutory aspect of it. So the applicability of 922 G4, not the constitutionality of it, but rather the applicability. See, there's a difference between constitutional law and statutory law. So the court used the constitutional avoidance doctrine to rule on statutory grounds that it didn't apply. Therefore, because of that, they got the injunction to remove their names off of the NICS database system. I know it sounds very convoluted, but if you were ever held with a 72-hour hold, then that's another avenue you can go down if you file an injunction in a state that does not allow federal relief, basically. That's another option too, technically speaking. But that's only if you have not had your day in court. That's it. If you did, then that is not a defense. But if you did not have your day in court, you weren't brought in front of a judge, you didn't have an opportunity to be heard and this and that, then then you do have a case. But if you did have that, then you don't have a case, basically. I really wanted to add that too, just so people understand that. Because like I said, how you file certain things are very particular, because the other cases, at least where I live, the Jeffries versus Sessions, Simpson versus Sessions, Barr versus Attorney General, Doe versus the governor of Pennsylvania or something like that. There's a couple of New York cases, a couple of Arkansas cases. They all lost their cases because of what I mentioned earlier. They argued in the wrong way that made them lose their cases. What you argue is very particular and very specific. None of them had government jobs, so none of them had that ability to argue the presumptively lawful aspect of it, because it's presumptively position that you don't have the right because you were committed involuntarily. So you have no Second Amendment right. But also in the fact that they didn't argue the applicability of 922 G4 because their lawyers said to argue the 14th and 5th Amendment and the Second Amendment, basically. So they got fucked in that aspect of it. But that's different than Wilburn versus Barr and Franklin versus Sessions, because they argued the applicability of 18 U.S.C. 922 G4 on statutory grounds, not constitutional grounds. That is only if you didn't have your day in court. If you did, then you argue the constitutional aspect of it, because 18 U.S.C. 922 G4 is constitutional based off of the recent Rahimi versus United States case. You cannot, like I said, argue a facial claim, which is saying the whole statute is unconstitutional because you presented a clear and present danger to yourself. So yeah, that's not unconstitutional for facial challenge. But the continuation on an as applied challenge for the continuation of the statute to be applied to you, it does not apply to you if you hold a government job and you have proof that you're able to possess a firearm within that government job, and you own other weapons that are not firearms that you're legally allowed to own with the state, federally and state-wise. So, like I said, do every loophole we can and listen to what I said on this particular issue, because specifics are very important. So if it's convoluted and it's a little bit confusing, I apologize, but wanted to add that also too. So yeah.